Good afternoon. This is Attorney Peter Olson, Chicago Family Law Group. Just doing another one of our quarterly webinars. And I'm just about to get going here. I think we have a few people on the call, and in my experience in doing a lot of these over the years, people will jump on after the fact. And alternatively, obviously part of this is something, that we record and use for sort of future reference as well. So it's two audiences. It's the live audience and it's the after audience. So I think you can chat and whatever if you need to. Definitely toss me your questions and mention if you're having any technical difficulty. I'll try to get it straightened out. I use GoToMeeting enough to be proficient, but not enough to say I'm an expert. So. And I'm going to go ahead and share my screen. I hope we're getting the right view here. Just going to double check. Just have a slide package. Actually, haven't done this webinar before. We have a few boxed webinars that we write, just sort of traditional repeating family law topics that that we're doing a lot of. And this is just a new one, actually. I created a blog post and done a newsletter recently, just sort of our firm newsletter. And this was the subject of a blog post. And just sort of when you're thinking about this stuff for other reasons and doing stuff for other reasons, I'm like, maybe I'll just do a quick webinar on this topic as well. So here we go. 8 good reasons to return to court post-divorce. 8 good reasons, because there's a lot of reasons, and there are a lot of cases that are in court post-divorce, post-judgment, and not all of them are good reasons. I'll just put it that way, and and that's sort of a subjective call. But here's where I'm really trying to emphasize. It's sort of like, here are the things from 16 years of experience where you can really affect change and make progress on matters that you might want to do and pull back into court, after a custody judgment was entered several years ago, after a divorce judgment was entered several years ago. Because I feel like a lot of people spin their wheels and are in court a lot post-judgment, and just from experience, there are areas where I believe that you'll just be spinning your wheels rather than actually making progress and affecting the type of change that you want, right? If you're going to spend time and money, let's make it worth it. So I'm Attorney Peter Olson. I'm a managing partner here at Chicago Family Law Group. We're a divorce and child custody firm solely. That's all we do in downtown Chicago. We practice in Cook, Lake, and DuPage counties. And I've personally been doing this for 16 years, and our firm has a whole team of attorneys and customer support staff. We're passionate about supporting families and protecting children in some of these contentious matters. So you can check us out at familylawchicago.com. There's actually a new chat feature there if you want to, if you have like immediate questions, boom. I think my email is probably on the last slide in this package. And thirdly, you can, we always do a free initial 45-minute consultation if that's of interest and you really have a specific personal question. So here we go. Let me start off with this because this is my big kind of top level statement. There are going to be exceptions to this, but I find that courts are going to be much more aggressive in their enforcement on and involvement with monetary related things versus non-monetary related things in terms of post-judgment enforcement stuff. So that's just a real top level thing. And there are going to be exceptions to that because actually a number of these 8 reasons are non-monetary issues, but that's my just top level take, that a court is much more aggressively going to be involved in changing and enforcing money stuff than they're going to be involved in with changing and enforcing non-monetary things. So I'm planting that seed because that's a bias I've seen over the years. And then the other practical point of it is it's much easier to get monetary issues to sort of a black and white, clearly, income, what's been paid, what hasn't been paid, versus, he or she is late bringing our son back all the time. One of them is very clear. One of them, the non-financial, tends to be a little mushy. So here's my first one, right? Stopping child support, stopping maintenance payments. That's absolutely right. It's very cut and dry. It's usually fairly easy to do. And right, if you're paying child support or if you're paying maintenance to to another parent or a former spouse, you probably would like to stop that at the time that you're entitled to stop it, right? There are circumstances, I think, where you wouldn't even need to go back to court on this. If you're just totally paying on the side, or you yourself are making payments through the Illinois State Disbursement Unit. We just had a case like that where actually we flipped custody over to the father on this case, and his child support was terminated, but it wasn't being garnished. I think he was self-employed, so he just stopped paying. He just stopped paying child support, and that was the right thing to do. However, in I would say the majority of cases, for the reasons of protecting yourself, and then the other piece of if somebody's having child support withheld, via an employer garnishment, oftentimes an employer is probably going to demand a specific court order that stops the withholding because, frankly, there are employer penalties. So this is a great reason to go back to court, right? I mean, this time of year, we always have multiple times, and I can think of, multiple times in the last month. Just last week, actually, right? I terminated a client of ours, his child support obligation because his son is set to be graduated from high school in a week or two here. And I'm not going, this is sort of overview level stuff, but right, those are some of those points where you're going to be terminating child support, age 18, age 19, or high school graduation. I would say most of the time it's going to be high school graduation, not always, but it kind of really just depends on sort of the timing of a kid's birthday. So that's reason number one, right? You're motivated to stop a financial payment. Reason number two, similar but different, right? Again, as I said up front, my focus tends to be on, I think the money issues are the areas where courts are going to intervene more aggressively, and it's more easy to kind of prove your case, lowering or raising child support. Reason number two, lowering or raising child support or maintenance. When are you going to do it, right? The structure of the family, you have multiple children, and now one of them is graduated from high school, and so that would be a reason to modify child support. Those are your two big reasons, right, where child support's going to be changed. Child-related family structure, basically number of kids-related changes, or income of the parties change. So, that's reason number two. Last year, I can think of multiple cases when Illinois' child support law changed. And check out our YouTube channel. I have actually a more extensive video on this because the new Illinois child support law, I say new, it's almost a year old now, but it's still right. It's a dramatic change from what was happening, for the 20 or 30 years we had this other law in place. What we see a lot of is when there's a fairly high income earning custodial parent, the new law really allows the paying parent to lower their support quite a bit. So keep that in mind, and you can't just rely on the fact that the law changed. But here are two examples. Well, the same example in two of our cases just recently, where these two men had two children and have two children, but then one of them aged out. One of them was graduated from high school, so therefore the court, there was a change in circumstances that allowed us to pull the case back into court. And now, hey, great, we get to apply the new child support law that allowed us to use this new formula that takes into account both parents' incomes. And because in these two particular cases, the custodial parents were actually fairly high income earners, that income sort of worked against them. And therefore, there were two cases recently where we probably lowered these guys' child support. Probably it was roughly in half, if I recall correctly, from those two specific cases. But so think about those scenarios. Those were actually at the end of last school year. But if you have any of those this year, think about it big time. If you have a case with multiple kids and you haven't had your child support changed since the new law went into effect, and the other parent earns a fair, I'm just saying 40, 50K per year or above, those are cases where we've gotten big reductions. So again, reason number two, go to court post-judgment to lower or raise child support or maintenance, right? It's really the same standard for either of those. Substantial change in circumstance since the time the order was entered. And it's almost always going to be child related, number of children you're paying support on changes, or income changes, either of the parties income changes. So that's reason number two. Hey, reason number three, here's the first non-financial one. I told you, that's just my top level bias that I think it's easier and more clear for courts to make changes on money versus non-money. But there are absolutely some non-money things that are good reasons to go back to court on. Here's number three. Changing custody of a child or children. Change custody of your kids. This is absolutely the most difficult and most serious sort of post-judgment change or modification that's out there. It just is, right? You have a custody judgment that was entered several years ago, and now you're actually asking for it to be changed. You're not just polishing around the edges. You're not just changing a pickup or drop-off time. You're not just modifying transportation a little bit. You're basically asking a court to totally what? Pick up a kid from this life circumstance and move them into this other life circumstance in terms of, right, home life, social life, location, etc. So it's a big change, and it's absolutely the most difficult, most serious post-judgment change. The way the law is, it's almost impossible to do less than 2 years post-divorce or post-custody judgment. It's just, there's a real high standard. It needs to be the verbiage is sort of, there needs to be a real serious threat to a child's physical, mental, emotional well-being within 2 years. It's possible to change it. I've done it, but unless you have something really extreme, you're not doing it within 2 years. And to be blunt, the reason why I say, just from a lot of personal experience, that this is the most difficult and serious changes, 2 years or not 2 years, you need the only facts that are going to essentially get a judge to move to change custody are going to be serious facts. I feel like, or I've experienced this, is you get a lot of people calling or suggesting, hey, I want to change custody. And it's usually low level petty stuff. And then, my objective take on those situations is not going to happen. You probably shouldn't waste the next 6 to 9 months of your life in court because of some low level thing you don't like about your ex-wife, or maybe your son or daughter had a bad semester in school. Maybe you don't like the new significant other. Maybe they moved to a new neighborhood and, blah, blah, blah. So that kind of stuff you hear a lot, and that's usually not going to move the needle. When I think of examples, real world examples of cases where we've changed custody, and I'm thinking of 1, 2, 3, maybe recent ones, it was really, really, really serious stuff. I'm thinking of a hearing we did in the last couple of years when I list here poor school performance. In this particular case, the mom, when the kid lived with the mom, the kid was just like hardly ever going to school, doing poorly. I mean, I'm thinking back to that hearing. It wasn't that long ago. And, some of our main evidence absolutely was school attendance records and school grade reports. And they were just awful. So that was a big one. Suicide stuff, that was another one that's top of mind. Some serious problems were going on in the mom's house in the case I'm thinking of. And, she had a couple, sort of adolescent, I'm forgetting, 12, 15 aged girls. And, one of them was cutting themselves, herself, and, just real serious stuff. And then one other just really great result, we got a client where we flipped custody, again, changed custody post-judgment, was it was a lot of visitation denial. It was a guy who, a solid parent and a parent who wanted to be involved, and there was a custody judgment, the divorce judgment, just had a normal parenting setup. And what was happening was the mom was just abjectly denying our client's parenting time. And just eventually it got to the point, and it got to a level of extremeness. This wasn't one weekend. This was like basically all the time. It got to such a point where the judge flipped custody. And that was the basis of it. If the kid is not with the father, he's not going to see the father, period, right? And so it's like it's either custody with this parent, and then the kid's going to have a relationship with both parents, or it's custody with this other parent, and one of the parents is going to be totally cut out. So that's reason number 3, good reason, right? Number 3, to return to court post-judgment, and that's changing custody of your kids. And these have been some of my most meaningful, rewarding results in cases. Absolutely. Because these have been extreme situations where essentially a kid's life has been really improved by the change. But take the point seriously, that it needs to be serious, concerning, high level issues. It's not something you go into court on, minor, being upset about some minor issue. Reason number 4, paying for college. Side note, if you go to our Facebook group, Chicago Family Law or Facebook. Is it a group or is it just a business page? Forget about all your Facebook vernacular, but I did a short video more specifically in depth on this topic. I think over there, it's either a video or a Facebook Live, that's up on our Facebook business page on this very topic. A good reason to return to court post-judgment is to pay for college. If your son or daughter is going to, and I actually should have phrased it differently on the slide because it's broader than just college, and I'm not looking at the law right now, but it's college, trade school, vocational training. It's basically any sort of, I think, loose instruction that happens post high school until a son or daughter turns 23. So not too many people are not pursuing child support, right? Kid from birth to age 18 or high school graduation. But I'm always amazed at how few people, at least my perception, actually pursue college expenses, right? It's a lot of money. It's money that's available just like for child sports. Really, the way I look at it is just it's called something different in the law. There are two different sections of the law. So, I deal with it different. The courts have a different standard, blah, blah, blah. But at the end of the day, it's money, just like child support's money. So you might as well pursue it because you're entitled to it as long as your son or daughter is doing some post-high school educational stuff. And I'd refer you to the Facebook group video, Facebook page video for a little more depth. But it's early, in terms of when, what, how decided sorts of things. Second semester of a kid's senior year of high school. It's a pretty large circle in terms of what: tuition, room and board, sometimes home living expenses if a kid is at a junior college. How's it decided? Generally, it's really a fairly easy, simple case. It's looking at incomes of parties and assets of parties, and the court is usually going to somehow divvy up the majority. I'm going to say 80 or 90% of the expenses between the parents. And then usually the son or daughter will be on the hook for a little. But, there's money available for an additional 4 or 5 years. So get what you're entitled to. Get what you're entitled to. Reason number 5. If you want to, and I guess, right, we can be on either side of this case. If you want to relocate more than 25 miles from your residence, if you're the majority time parent, or I guess alternatively, if you have another parent either wanting to do this and then you're kind of pulled in court to defend it, or one of the more popular and abused things is, a parent does this without getting court approval. And then that can be a good time actually to maybe get possession or custody of your kids because another parent did an illegal move. But this is the law right now within the Chicago collar counties. I think the 5 or the 6 Chicago area counties. A parent cannot relocate the residence of a child more than 25 miles without a court, either the other parent approving it sort of in advance, or alternatively getting a court to approve it. And this is a change, right? A few years ago, it was anywhere within the state of Illinois. I mean, for my, early part of my career up until 2 years ago, it was anywhere within the state of Illinois. Now it's this 25-mile thing that changed, I think, January of 16, 25 miles. So the reality is, right, there are a lot more of these cases than there used to be, right? In our office right now, I can think of at least one where it's essentially a person wanting to move with her daughter from the city of Chicago to sort of a far out suburb. So now you're more than 25 miles, and now you have to be in court on that issue. Whereas, before this legal change, if you just wanted to move to a far out suburb, that wasn't Kenosha, Wisconsin, or Valparaiso, Indiana, you could just do it. So I'll be curious as we do more and more those situations. I've done a lot of these historically, but how will courts view just the move to the suburbs kind of deal versus, moving to San Francisco? How are those, the standards are really the same, but I'm kind of curious because I don't have enough sort of history with just the move to the suburb cases, just because the law's, recent enough in terms of are most courts just going to grant those, because it's, how's that going to affect somebody's parenting time, just having to drive a couple more miles versus, somebody moves to San Francisco, the parenting time setup's going to be a lot different. But to go into a little more detail, right, I definitely do think after changing custody, a relocation case, I do think of as sort of the second most difficult thing to do. And at a real top level, you're really balancing, in terms of what facts you would need to bring to the table, you're really balancing how does the move benefit the child? And I think of it as sort of the direct stuff with the child, how is the new school district, how is the new community going to directly benefit the child? How is the other sort of the common cases here are, is the custodial parent maybe getting a promotion or a new job that's paying him or her more? So how is that, doubling of income going to help the kid? That's what I talk about, indirect benefits. So just jotting down a few notes on my slides, right, to just sort of be ready for the presentation today. These are sort of the typical ones you get a lot of. The new fiance, the new spouse who doesn't live local. And now, I want to get married to this woman in, Tampa, Florida. So that's a common driver. The new job, a common driver. And here's another one. I was actually just speaking to a prospective client a couple days ago, and we had this case too, where sort of post-divorce or post-separation, somebody wants to move back to sort of where they're from and where their family is, sort of the support system idea. That's another one. I can think of actually two specific cases. One we just won in maybe March, and one maybe a couple years ago. Same idea, where these were both women custodial parents. They weren't earning that much money, and they weren't actually getting paid that much in terms of child support. So it was like, hey, I want to move back to, I think one of them was like Knoxville, Tennessee, because that's where my parents are, and I have a bunch of, adult siblings, and now these two small children can be cared for a little better. So those are sort of the drivers on the person who wants to move side of the case. And to me, the other side of the case really is how involved is the other parent? Because I can think of a notable case where I stopped a woman from relocating, and it was to California actually. And the issue was this, is our client, the father in this case, was a very involved parent. And those are difficult cases to win. That's why I think that's really the really key issue, is how involved is the other parent, right? Because if I'm a judge looking at a case, I'm going to ask myself, am I basically taking these children out of this, their other parent's life in a dramatic way or not? You can tell me about all these little fringe benefits about the great school system in, San Francisco, and your income's doubling, and your parents live out there, blah, blah, blah. But I wouldn't think that would be nearly as persuasive if on the other side, it's like, but wait, I'm not going to pull these kids out of a dad's life who's seeing them, every few days and is going to their sporting events and going to their school parent teacher conferences. And that's the case I had a few years ago. My memory of it is that this guy was seeing his children 3 out of every 7 days. So that was really persuasive. He was current on child support. He was seeing his kids 3 out of every 7 days. So thinking back on that one, and I think the judge did the right thing. It's like, I'm not, just because the other party in that case, she'd gotten remarried, I believe, and there was a little bit of an income bump. So she had a few things on her side of the table. But when the alternative, if the move happened, literally, right, you're really ripping these kids out of their fathers, one of their parents' lives in a big way. So how involved is the other parent is really, really crucial in the relocation cases. Reason number 6, good reason number 6, if you want to restart parenting time. For many reasons, we don't have to, a parent will get pushed out of their kid's life. And sometimes I think it's directly related to the contentiousness of a divorce or a custody case. And so now they've been pushed out of their kid's life. And now we're a few years into the future, maybe more than a few years into the future. And I want to see, my son that I haven't seen in 6 years. So this is absolutely a good reason to get back into court, right? 2-parent families are generally going to be the better environment in which to raise a kid. So, get back into the picture. Now, and I list this and being very blunt, it's going to take some time. Warning, right, requires commitment and patience. And it does usually involve a little bit of ramp up, and usually it's going to involve, some mental health sort of therapy, help a child, right, readjust to this person who's been out of his or her life for a few years and bringing them back in. But when I say ramp up, I'm just saying, if I've been out of my son's life for 6 years and now I want to get back into my son's life, it's probably not going to start with, okay, you start to have, 40% parenting time, overnights, no restrictions. Usually, step number 1 is probably going to be, maybe a meal a week for a few months. And then, okay, that went great. And then let's expand it to a full day on Saturday, for a few months. And then maybe after that amount of time, right, after a little time of doing real short term and then real, maybe expanding it to a day, okay, now let's get it back to so-called normal other parent, parenting setup. But this is a great reason to get back into court, get involved in your son or daughter's life. Your bias in this space as a family law attorney, right, is sort of a court really only has power over these kids, right, in the custody and visitation, parenting time issues until, right, they turn 18, because then they're an adult. I used to definitely have a bias, kind of like, if you have a kid who's 13, I don't know, make up a number, but 14, 15, 16, is it really worth the effort to push back and kind of to restart parenting time? I think my bias used to be probably no, it's not. But the thing about it is even though the court system's power ends at 18, the reality is you're talking about, a 60-year relationship in reality. And sometimes this is the time to push it when they're still a minor, because after that, it might be too late. So I think even as you get older kids, into their mid-teens, it's still worth it, because really you're talking about a 60-year relationship and not 18 years. And the question is, how do you get back in there and develop the relationship and the trust so you can have it, right? I'm 44. I still have close relationships with my parents. They're not divorced and all that and whatever, but I mean, that's a side issue. But right, I mean, divorced or not, separated parents, the issue is, right, you're talking about a real long-term relationship here that you should encourage. But absolutely, it's not easy to do. It's not easy to do, and particularly when you're talking about out-of-state situations. We have a number of these going on right now where we're helping clients do some ramp up with quite a bit of success, but it's hard and it's heavy lifting, especially if you're not in the area and you're going to have to be coming in semi-frequently or traveling somewhere else semi-frequently. So good reason number 6 to get back into court: restart parenting time. Reason number 7: enforcing financial obligations. Enforcing financial obligations. Again, right, in quotes, I'm not saying enforcing non-financial obligations, but we'll do a sidebar on that in a second. But right, if somebody's not paying child support, if somebody was supposed to pay you X number of dollars in maintenance, if somebody was supposed to pay you X number of dollars in a big divorce settlement and they haven't done it, right, that's contempt of court, right? That's basic contempt of court in a nutshell. There was an order, he or she's not following it, and there's not a good reason why he or she is not following it. And if somebody's held in contempt of court, you're going to get an attorney fee award against that person too, right? Because the only reason you're going back to court is because he or she wasn't following a court order that was previously entered, and there's not a good reason why he or she wasn't, following that previous order. So this is a great reason to get back to court, to be honest with you. And I would just say the caveat there is just to think about, is this a person with assets? Is this a person with employment, income, etc.? That's the only thing that might give you pause. If this is a person who's indigent, without assets, without work, without a home, these sorts of things, and there's nothing really to collect against, then this could be a situation where you're spinning your wheels, and then it's, why waste your time? But if you have somebody who, doesn't want to be getting locked up and has a home, has income, has retirement benefits that can be, locked onto, this is straightforward stuff. I was literally sitting in a courtroom this morning, 2 hours ago or less, and this wasn't my case, but, just observing other stuff, and, judges being very stern with a gentleman, basically threatening lockup, and, he's turning over 16 grand to his ex-wife. So enforcing financial obligations, assuming there's stuff to enforce against, absolutely worth your while. Absolutely worth your while. And here, what's the last reason? Step-parent adoption. Step-parent adoption. It certainly isn't, excuse me, something we're doing nearly as often, probably as those previous 7. But I've done a few of these now to the point where I'm thinking about it and sort of pitching it out there a little bit more, because it can be a good play. And that's sort of the question: has the other parent disappeared? And are you married or remarried now? Basically and we're generally going to be talking about the male, right? Do you have a new husband, or do you now have a husband who might be interested, in your, doing an adoption, right? In essence, right? Me, as the step parent and the second husband now, going in and adopting a son or daughter that's not my biological son or daughter, but is right through a previous, other parent, former spouse, whatever the case may be. The reason why I've sort of started pitching these, honestly, is a good and a bad example that I've seen recently, one of which I'm involved with, well, both of which I'm involved with, and here's kind of the good and the bad. And both were in that same sort of fact situation. You had the same facts of a child, a parent, and in both cases, the biological father being out of the kid's life for extended periods of time. And so now what do? Do you do anything? What do you do? And then here's where I'm teeing up the idea of step parent adoption being a nice idea and a smart idea. In one of these situations, we're in the midst of a step parent adoption. This guy's, way behind in child support and hasn't seen this kid for years. And this other gentleman, second husband, has been absolutely the father figure for, a decade now. So this is a step parent adoption case I'm currently involved in. Now, let's talk about the bad example, because this is a case we were also honestly sort of involved in, and they hadn't done the step parent adoption move. And here's how it ended up. The other case I'm thinking of, the bad case, was the parent did nothing. And then so what happens? When are we getting back into this situation? Because now this father, the biological father, who's been out of the picture for years, and I believe in this case had actually been incarcerated for many years. So the step parent adoption absolutely could have been done. This woman was remarried, and this guy had really been the involved parent and the active parent for many years. Same exact fact situation. But they do nothing. They just sort of whatever. Oh, maybe the guy's gone, and but here's the deal, and here's where it kind of blows up, and it's just upsetting for everybody, including probably the child. Now father wants to get back into the kid's life. Many years. Now he's coming back into court and stuff like, I want to restart my parenting time. I want to restart my visitation. And so, and the reality is, because an adoption wasn't pursued, which is right, it's a permanent termination, this guy can just come back in, and what's the result? The kid's probably negatively impacted. I know one of the parents that we were representing was really, really upset because, she thought this guy had disappeared. But since she had not done anything by way of sort of an adoption to make a permanent kind of resolution where that guy's out, the reality is he could just come back in and, restart parenting time. And it was more of a ramp up, but it was still something where I know her preference, if you asked her, would have been great if I could have just terminated this guy's parental rights and he would have been out of the picture permanently. So step parent adoption, not an everyday thing, but not that unusual, and something to consider if you have that fact situation. One of the parents out of the picture for a long time, and are you concerned that he or she is going to pop their head back into a kid's life, and you don't want them to, and you want them to. So with that, what questions do you have? Either chat them. I'll hang out for a few minutes here. That's some information about booking an appointment. That's some obviously phone and website chat information. But The reasons that I just put forth, I think, are really strong and viable reasons to, to take the time and the money to return to court on. Those are things we're doing a lot of. So, yeah, if you want the slide package, shoot me a note. Alternatively, I'm generally going to upload our webinars to our YouTube channel. So just, whatever Chicago Family Law Group YouTube channel, you can check it out there. So with that, I'm attorney Peter Olson, Chicago Family Law Group, signing off. Have a great Thursday.